Hi, welcome to This Week in Property. I'm Jayashree Kurup, I'm editor Magicbricks, and I have with me Prabhakar Sinha. He's the editor of real estate on the Times of India. And today we're discussing an issue which we feel may set the cat among the pigeons. The RERA regulator of Gurgaon has said that even completed projects will fall under the purview of RERA. Now, Prabhakar, this is a very, very bold statement for a RERA regulator to make, and there is a history to this, right? There are developers in Gurgaon who have already taken completion, but if there are if the units are being sold to consumers in the primary market, those projects, that is what the RERA regulator says will fall under the purview of RERA. Let's discuss the implications of this.
Yeah, now look. What regulator Mr. K.K. Khandelwal is saying that if any project which is already completed before May 1st, 2017 when RERA sets in, now what will happen if suppose some of the obligations that developer is not fulfilling towards its buyers, where buyers will go?
And this is happening across the NCR. We've deeply studied the NCR. There may be other states as well where
exactly.
the same.
Because when the RERA was coming in, at that time many people had just gone prematurely to the authority and took the completion certificate so that they could avoid coming under the purview of RERA. And because of that, many of such projects have not come. So then what happened that now as the RERA has started, many people who are suffering, because now suppose the developer is not registering the projects in the name of the buyers because there are some problem and the total completion certificate is not he is not getting. Because at that time OC could come, but the CC had not come. And on the basis of OC, they kept themselves out of RERA. But now as the CC is not coming because they have not fulfilled certain obligation towards the authority, so now authority is not giving CC, and unless CC is given, the registration can't be done. Now because of this delay, now certain things which developer has not done towards the authority, and so he is not getting permission to register the project, but the buyer is suffering.
Yes.
So now
because he's taken an occupancy certificate.
And he's living also in that.
Yeah.
But suppose now he wants to sell it because he has to go somewhere, or he had bought it for the education of his son or daughter. Now he wants to sell it to take money so that he could invest somewhere else. But now he can't sell it because he can't register the project. So the authority is saying, the RERA is saying, ki boss, here where the buyer will go. Should he go to the other court or should he come to the regulator itself? Now what his argument is that in the 10 chapters of Real Estate Regulatory and Development Authority Act, only one chapter is about the registration of the project, and in no chapter it talks about where the chapter which talks about that how the act has to be implemented. It talks about that the act will be implemented only on the registered projects. It says that there are certain provisions on the projects of that region, not on the registered projects of the region. So why only he limits himself to the only registered projects?
This is the Central Act. The State Act, the states have said that if your project is taken CC, then it is out of RERA. That was in UP that till December 2017, if the projects had not taken their CC. If it had applied for CC, it could be out of. So you see the states.
Now that has also a story. What he says that the registration process is for the different purpose. Basically, it talks about when the those projects which are going for the construction, the projects need to be registered so that during the construction period, it should also be monitored. Yeah. That where the money which the buyers are paying the money, that money should go to the escrow account so that the money should be used for only the construction purpose. Right. So that the project could be completed on time. So for that purpose only, the regulator has made it that the project has to be registered and developer the
money has to go into the escrow
account and the regulator will monitor it. Right. But that doesn't mean that those projects which are completed earlier will not come under the RERA and they will not regulate it. No, so not only that it is before 2000. They say some projects 1970, 1980, any time if a project is completed and there are certain obligations which is left due towards the buyers by the developer. then that buyer can approach RERA authority that was my developer had not fulfilled this obligation and I have come to know of this development now, so please ask him to fulfill this obligation. And he has to do it.
And he is actually quoting, Mr. Khandelwal is quoting a Bombay High Court Justice Patil's judgment, where it says that merely because sale and purchase agreement was entered into by the promoter prior to coming into force of RERA does not make the application of enactment retrospective in nature. In December 2017, the Bombay High Court has upheld the constitutional validity of the Real Estate Regulation and Development Act and its applicability to ongoing projects across states. So the logic that Mr. Khandelwal is using is that if you have not given those elements that you had promised to the consumer, the project is still under construction and not fully completed.
And even if it is completed, now suppose a project is completed, after getting it completed, it goes outside the RERA, but now suppose there is some structural defect develops. According to Act itself, the buyer can approach RERA.
Right.
Despite the fact that project is completed and it is no more with the RERA.
Right.
So he says that a project is completed doesn't mean that it should not be and cannot be regulated. He says that it is regulatable and we will regulate it.
So let's go back to those provisions, Prabhakar. We've picked up some of the provisions of the Act, which probably supports Mr. Khandelwal's argument. There is where any person, what is the obligation of a promoter regarding the veracity of advertisement or prospectus?
Exactly.
And that is what we're talking about right now.
What he has promised, he must deliver.
What you have promised, you have to deliver. Where any person makes an advance or a deposit on the basis of information contained in the notice, advertisement or prospectus, or on the basis of any model apartment, plot or building, as the case may be, and sustains any loss or damage by reason of incorrect false statement included therein, he shall be compensated by the promoter in the manner as provided by the Act. Now, till now, across the country, we have interpreted that as of 1st May 2017, when RERA came into force, projects which were under RERA and with a RERA registration number are the ones where you can go to the regulator. Mr. Khandelwal is breaking that thought and saying, no, if the project was not registered with RERA, there was an occupancy certificate that was given. But if the project is still being sold or there are elements of the project that have not been
even if the project is sold and completed, but they had not fulfilled all the obligations, then the buyers were supposed at that time thought that they should move to NCDRC or some other court. Now those buyers can withdraw their application from the other court and can move to the RERA asking relief from the RERA. That this because now his thought is very clear. He says that RERA is to regulate the real estate and there cannot be n numbers of regulator to regulate one particular sector. Each sectors will have only one regulator. That is what the government thinking is, and that is how the government has come out with the RERA.
So let's talk about other sectors where regulators were brought in the middle of an operation.
Like
TRAI,
yeah.
IRDA,
yeah.
SEBI. These are all market regulators for different sectors which came in. Do they function with retrospective effect?
Exactly. Now suppose if you have bought a policy much before the IRDA had come in. Now does it not mean that? Does it mean that no, if you have bought the earlier policy, the policy writers, means that company from where you have bought it, should not, and if he is not fulfilling all the obligation, you cannot go to IRDA. Yeah. IRDA has to regulate it, and IRDA has to address that problem of the buyers, of the customers, and IRDA is doing it. So similarly, in the case of RERA also, now if you have bought a property earlier, you have already received the property, but afterwards you realize that they had not fulfilled certain obligations which they had promised. You have all the rights to get it addressed through certain courts.
So has Mr. Khandelwal actually adjudicated on any case?
He has adjudicated in one of the cases. And the RERA, this Panchkula, they have already given one judgment on the basis of this philosophy, and the buyer, basically the developer, had argued that because they had already taken the completion certificate or the occupation certificate before RERA had set in, and so they don't come under the purview. They say that no, you do come under the purview, and we will review it, and we will give the judgment.
This is a very significant judgment, and we think we should help our consumer understand
this means that this particular thing, if it is upheld, now suppose today that developer against whom the judgment has come, if that developer goes to the Chandigarh High Court, now Chandigarh High Court also upheld the RERA judgment. That means this RERA judgment can other areas RERA like UP RERA or Maharashtra RERA or anywhere else. Now there, if a customer moves to the RERA asking the similar relief, RERA can't say that no, we can't hear your case, because if the Haryana RERA is hearing it, they have also to hear that case, because ultimately Haryana RERA is defining the very purpose of the RERA itself.
Right.
And he is expanding the scope and bringing in more and more cases into the RERA system. So now other RERA, should not say. If they will say it, I believe again the court will have to intervene. Now because, at the same time, another part what he is talking about, that now suppose he just limit himself to the under construction projects. He says that now many of these developers is trying to find out ways where they don't want to sell the project during the course of construction. That means that no project will come under RERA.
Right.
Because they don't want to be regulated.
Right.
So will the government or any system allow this to happen?
Actually, there are two things here. Developers who don't want their money going into escrow accounts can actually take the money, build the house and sell it. That is one part of the thing, which means that during the period of construction, is RERA regulating their construction? No, it is not. And they complete the project and then create a prospectus and sell it post the development of the project. But what Mr. Khandelwal is saying and what Haryana RERA is arguing is that because you completed the project on your own terms does not mean that you are not liable to be adjudicated by the RERA tribunal. As in any other sector, like we said, the TRAI for the telecom sector, the IRDA for the insurance sector, SEBI for the stock markets, whether you bought the project registered with that regulator or not, or during the term of that regulator, de facto for that entire sector, this has become the new regulator.
Exactly.
And RERA regulator is saying that RERA has to be the final authority for the real estate sector. Beyond this, there should not be any other reason to go to any other forum.
Exactly.
Right?
That's what he's saying, that ultimately we are the regulator of the real estate sector. Now, whether the project is completed, not completed or going to be completed, it doesn't matter. Right. Now, if a customer has any grievances, he wants that redressal of that thing. Right. Now, where will he go? Now, we are as a regulator, if he comes to us, we can't say that no, we can't hear you, you go away.
Yeah.
And go to the High Court.
Right.
Because the High Court is a general court.
Right.
So naturally they will come, and after our judgment, if they want to still, they are not satisfied, they will go to the higher court. But the first step is there.
We need to actually let you know that when we spoke to the Maharashtra regulator, the Gautam Chatterjee, what he said was this is a new law. And a new law is always subject to interpretation. It becomes more robust as it is interpreted. And today what's happening in the case of Mr. Khandelwal is he is interpreting the law and challenging the notion in the market that RERA can only be adjudicated by for those projects that are registered with RERA.
Registered with the RERA.
Registered with
He says that even suppose a project which is on less than 500 square meter, they need not to register on with the RERA. Now suppose and they have built less than 8 units and they are selling the customer. But the customers are realizing that they have not fulfilled all those promises which they had made before selling at the time of selling of that projects. Can they not approach RERA?
Right.
They say that now his thinking, and that is what he says that the law is saying so, that the entire thing should not be registered because that is small enough to monitor the funding and other things during the time of the construction. But that doesn't mean that
it is outside the purview of an authority which has to.
And if there is any dispute between customer and the developer, the authority will not intervene.
Right.
So he has the right to intervene and he can intervene. And that is what the law says. He says that this is not, I am saying, This is what the law says, and you read the law carefully and you will realize that in the act this is provided for.
So anybody who builds a project and sells to a buyer comes under the purview of RERA.
Exactly.
And that is what the Haryana regulator is saying. Now, this is very significant in the light of what's happening in the NCR, where we are seeing a large number of projects illegally constructed, which are collapsing, people are dying. And last week we picked up this issue, and Prabhakar and I were discussing what is the recourse these people have. There are two things that you have to keep in mind as a consumer. The first is that you must have a builder-buyer agreement. The RERA Act says that more than 10% of the price if you are paying, by that time there should be a builder-buyer agreement which clearly defines what the builder agrees to sell and the buyer agrees to pay for.
And that needs to be registered now. I believe that under RERA, when a buyer pays 10% of the amount,
that builder-buyer agreement is registered with the authority.
So then you are the basically legal owner of that property, and so you have the claim. Even if suppose the latter stage, I mean, God forbid that should not happen, the project goes to NCR, LT and other places, still you have the right on that property, and you are not just a financier that you should get a certain proportion of the money and get out of the project. Yes. No. You are the not
buyer
the
of a unit in that construction.
You are the owner of that unit. The unit is registered in your name.
Right.
It's a very unique situation.
And the bank or the lender is lending to that one unit which you have agreed to buy. So there are multiple responsibilities here. The developer is responsible that he has got a project that has sanction, that is legally valid and which can be banked. The buyer is entering into an agreement with the developer, saying that I'm buying a project. He's listing down what he's buying, and he's going to the lender saying, this is the project, this is the agreement between the developer and me, and therefore I need funds to buy this. The banker is entering that. If any one of these three arms,
and the agreement is so strong that with the backing of that agreement, he is the owner of that future property, and he is mortgaging that property to the bank, and bank is accepting it.
Absolutely.
Bank is accepting it. So its sanctity has to be measured in this light, that the buyer here is mortgaging that property and taking loan from the bank.
Right.
Okay, so the regulator is saying that we are responsible for the execution of that agreement, and that agreement has to be full and final, and the buyer and the seller, the developer, has to meet all that is promised in that buyer's agreement. And that is why now they have prepared a model code for that agreement itself, and according to that only they have to sell it. But in the earlier selling, suppose somebody had bought in 2004, 2005 on the old agreement. Now he is saying it. I asked him one more thing, and he is very, it sounds very good. He says that now for the delay period, basically, buyer has to, if the buyer has delayed in making the payment, normally as per the agreement, they have to pay 12% upwards, 12% to 18% interest rate. Whereas the builder has to give only 5 rupees per square feet compensation. Now 5 rupees per square feet or 10 rupees per square feet compensation comes out to be peanuts.
Yes.
So he says that this is not level playing field.
Yeah.
And that is why he said that wherever that level playing field is not there, they are enforcing as per the agreement, that 2 percentage point over and above the SBI MCLR rate, they will both have to pay for the delay period, the buyer as well as the developer.
Even for older projects.
Older projects. He says that there is no choice here in these cases. So he says that in Gurgaon right now he is implementing this. But UP is saying differently. UP RERA has issued a circular. In that he says that for the older agreement, now whatever it is mentioned, they'll have to go by that, and the builder will have to pay only 5 or 10 rupees per square feet, whereas the buyer has to pay. Now for the buyer he has not clarified, but builder will have to pay. But in an agreement where this is not defined, the buyer, the seller, means developer, will have to pay SBI's interest rate, MCLR rate, plus 2 percentage points.
But any project that was registered under RERA even after the registration, say 1st May 2017, even in UP, the consumer is entitled to get a SBI plus 2% MCLR.
No,
right?
no.
Even if the builder-buyer agreement was on the previous terms of 2%.
No. As per the circular, the buyer will get the damage as per the agreement only.
Does the agreement get redrafted?
No.
Which means that if somebody bought the previous agreements were always skewed in favor of the developer.
Yeah, so
and
it will remain like that till that the new completion date which that buyers has given to RERA.
Now this is clearly in violation of what the Central Act was intended to do.
Yeah,
when the Act came in, the central government,
this is a circular. This is the UP RERA circular, and I have the copy of that.
Okay. Now this is something that you as consumers can contest, because you were promised that when the RERA comes, the consumer gets justice, and justice means that both sides should be treated equally. If the project has gone into RERA and got a RERA registration number, and if the UP RERA still says that you are only going to be compensated for delay on the basis of a previous skewed agreement, this is something that you as consumers need to contest. And you can...
Yeah, but it seems that this circular basically is according to the existing condition in UP of developers, particularly if they will try to implement this SBI interest rate plus SBI MCLR rate plus 2 percentage point, then the interest amount, that damage that the developer have to pay will be so large that none of the developer would be able to pay and none of the project will be completed.
Frankly speaking, no, I don't think, I think that is just working in the around a specious argument. The point is that if the developer is not able to complete, it is for various reasons. He's used that money to buy other land, he's used that money to spend it badly, and it was not spent on the project.
Yeah.
The consumer has paid. The buyer should
Okay.
not suffer, and you as buyers have every right, and I would actually urge you as buyers to go out and challenge this agreement. In fact, we will put this out as a story. I'm sure Prabhakar would have...
I'm working on this, that I wanted to understand more about this. That
how can a RERA regulator work in favor of the developer, saying, poor guys, they don't have money. When they raised the money to build that project from the consumers, shouldn't somebody say, poor consumers, they don't have the money either?
Whereas Gurgaon RERA says that if that agreement is not as per the level playing field, on the philosophy of the level playing field, he says that we don't accept it and we redraft it.
Right. And actually there is a problem in the market. There is not enough money to complete the projects. As a result, and why is there no money? There is plenty of money for good developers, but there is no money being lent to those developers who are unable to complete projects for which they have raised resources. Today, governments are trying to see whether NBCC as one option, can they come in and complete projects which developers are unable to complete. There are lenders like ILNFS which are going to the better developers and saying, can you complete those projects, we will put in more money. But nobody is willing to throw good money after bad for projects where the developer has run out of funds. And this is the issue that is plaguing the NCR across all across the NCR, and there are many developers who are actually tying up with each other and trying to complete projects, or working with the consumers saying, put money into one tower, let's finish the tower, receivables come in, let's go to the next tower. So it's not that there are no solutions, and authority can never side with one side or the other, and should not be doing that. Let's take up some of the problems that are coming. We've got Vimal Kumar of Noida who says he got possession of his flat recently in Noida. He paid the entire amount, but just before the registration, the builder has raised another request for 16,000 rupees, saying that this is for an extended area. Am I supposed to pay this amount? Can I file a complaint with
he has to. As per the existing norms, particularly there are various high court judgments are there, which says that, and even RERA allows for a 6% extension of the area because of the construction, problem in the construction. And so if the area is only 6%, and if he has to, if the developer has asked only 16,000, that means this is very minor kind of an extension, so he'll have to pay.
This you probably have to pay, Vimal Kumar, but you have the right to ask the developer what is the extension. In some cases, Prabhakar, we have had queries on our forum where consumers say that the developer says that it is the common facilities that were extended, and there is no way of measuring how much of the common facilities, the super area was extended. And here the consumers are in a quandary, but our suggestion is that if it is smaller amounts like 10,000, 16,000 and so on, in the interest of getting your house and completing it, this probably is a much smaller amount. If the amount is much larger, you can contest it. But if you are unhappy with this amount, you are well within your rights to go to RERA and say that this is how much I was promised. And after completion, how can a developer let me know? Should he not have told me during the construction?
Yeah, now what happened, what you said it right. Like so far in NCR and all over India, developer used to sell it as per the built-up area.
Right.
Now built-up area includes the common area also. So now normally, and then they say that there is a loading.
Right.
That this is 25% loading, 27% loading. So that loading keeps varies. That good.
And that never came in the builder-buyer agreements.
That never comes under the builder-buyers agreement. And so you have to. Normally these guys have to pay and they charge accordingly. The good developer, in fact, they charge their builder. The common area is much larger. Proportion of the common area is much larger. And if the variation is even small in the common area, the buyer have to pay, heavily.
Okay, Prabhakar, we've got a query from Amit Khanna, who bought a plot of land in Ghaziabad. He has paid most of the amount. He was supposed to get the project in 2015. His plot of land is now has moved locations twice, and now he has got the he has been given a special request by the developer. He's already paid 7 lakhs more. He needs to be paying 9 lakhs more to get his project. But this is towards maintenance, advance charges of maintenance, and this is towards the club charges. However, the club is not made and the developer cannot pinpoint the location of the club either. Now, Amit Khanna's problem is, should I pay that 9 lakhs and take my plot, or should I challenge it? If he challenges it, will it go into a loop, because he needs to take that plot which is already delayed and he needs to construct on it. Can he pay that 9 lakhs and then go to the regulator and challenge it?
Yeah, he can.
And what happens? Does he get a refund then?
Yeah, but developer has to repay. And particularly in such projects, what happens that in future also you will have to pay. Yeah. So now suppose he pays 7 lakh or 9 lakh today, then he can be adjusted against the future payment. Right. So, he should take the plot first. That is what, as per the Indian system, it's unfortunate. And then you file a case in the RERA, tell him that this is how they have duped him. Right. And or otherwise, that will be better.
He should have in Amit. This is for you. You should get in writing from the developer that the club charges that you're paying today, the location of the club is yet to be finalized. You also have to have proof that while you are paying the advance maintenance charges, like you have mentioned, there are no street lights or provision for street lights. The drainage system is still under completion, and you're paying for facilities that the developer has not provided yet.
Now, all these things there must be in the contract. The buyer-sellers agreement, no? That he will be providing all this kind of facilities. Yes. So at least he should have that. Then after, whenever he is making payment, at that time he must, in that receipt it must be mentioned that okay, this payment is towards club charges and things like this. So that it can be proved that he has paid for the club, which is non-existent right now, but he is going to build it. And he should build a case like this, and then when he should get the plot so that he should start construction. And after that, meanwhile, he should move to the RERA so that all these facilities should be implemented, and if not, then the builder should be penalized.
You should be smart buyers today. The system is allowing you to be smart buyers. You were helpless buyers earlier. You needed a house, and there was a system that was telling you take it or leave it. Today, you are in the driver's seat, but you need to understand that if you are making payments and you know that those facilities are not complete, when you make the payment, you must make it clear in the receipt that I am paying for this and this, so that later you have grounds to prove that what you had paid for was for facilities that were not complete. Please do not just go and pay a 9 lakh upfront and then have no means of proving that you paid towards club charges or advance maintenance or whatever, and that these facilities were not complete. It has to be there on the receipt.
Take the plot, because if you will not take the plot,
it will go into a loop again.
Yeah, loop again, and the buyer may cancel it. I know a case where buyer has taken almost 70% of the amount, and they say that you pay the rest of the amount, and the buyer said, boss, you have not completed anything, the project is not complete, why should I pay you? He has cancelled him the allotment.
Is that possible? Can he challenge it?
He can challenge it.
But it will lead to further delays.
Yeah.
So our advice is that the system is not cleaned up yet, and therefore take your plot, and then once you've got it, then challenge the system.
Exactly.
There is Naresh Singh of Greater Noida, who lives in a high-rise society in Greater Noida where there are 12 towers. 8 are already complete and construction work is going on in 2 towers. His tower is completed and he faces a sewage problem too often. There are other issues as well, like no lift safety, and cleanliness is also not being kept properly by the builder. Can I move to RERA in this case?
Yeah, you can move to RERA also, and at the same time the authority also. And if suppose the lift is not safe and all that, then he should move to the authority, that because authority has given them the OC. Now OC is given only after all these facilities is fully implemented, fully fitted. Now if it is not, then the authority is also to be blamed.
So he can go to the Greater Noida authority and make a complaint that you're facing sewage problems periodically, that the lift safety is something that you are worried about, and that there is a cleanliness issue also. Today, thanks to the Swachh Bharat, cleanliness is an issue that you can pick up for to be addressed, and therefore I think you should make a complaint to the authorities. In addition to that, you can also complain to the RERA authority, saying that you have taken possession of a property, but there is additional construction work happening, and therefore you are facing all these problems.
Basically, this kind of a project, very unique situation is there, because he has got the part completion.
Yes.
So that means the common area wouldn't have been completed.
Right.
So the authority would not have certified that the common area is fully developed and things like that. And that is why this kind of a teething problem will come in.
Right.
And authority, I am telling you what the authority's reply will be, that okay, it's still under construction, things like this, so it will be improved. But that is not, I believe.
Therefore, it's important that you also go to the RERA.
Yeah.
Notify the authority, so that tomorrow if you have a serious sewage problem or a lift issue, you should be able to say that I told you so. I have already made my complaint.
No, but the developer gives the undertaking to the authority that those who are going to live in these apartments will not face any of such problems. So they have given the undertaking. Right. And authority gives them the completion certificate on the basis of only that such. Because remember, before giving OC, these authorities advertise also, and they ask any objections from the buyers, that if you have any objection, please let us know that there is a problem in this. And at that time in the meeting, they basically declare it that, look, the common area is not developed. Now whether you want to wait till the common area will be completed, or you want to shift in your house. So basically in such cases, the buyers opt for that, okay,
it's a Hobson's choice. What choice do you have?
Yeah, you have.
You've waited for 8, 12 years, and now would you say that I'll wait for another 2 years? It's possibly not possible for you to do that. But don't go as an individual, go as an association.
Yeah, that is the best.
Associations have far more power, and associations are being heard in the authorities as well as the RERA.
Now in both, in Noida also, in Gurgaon also, the RERA has asked the authority to cancel the completion certificate because the facilities were not completed or were not functioning properly. Right. In Gurgaon, recently they have done it. In Noida, there are 2-3 projects where the RERA has asked them to cancel this, and they have cancelled it.
Right.
So nowadays, the authority is also a bit in tenterhook that what to do and how to go about it.
We'll take another two or three more questions. There's Rakesh Verma of Delhi who says, is RERA applicable on under construction projects or completed projects as well? What does the law say?
Both.
The law say, till now, the authorities had said that it is on projects which are under construction before you get a completion certificate. Today's program is addressing an issue that the Haryana RERA Mr. K.K. Khandelwal has raised, where he says that any problems regarding the sector has to come to the RERA authority and not to any other authority. And we are actually stirring up a public debate on this. We are trying to create some consciousness about this. What should be the stance of the authorities? We will be talking to RERA regulators across the country to get their views on the subject, and we will continue this discussion in future programs. There's Mahendra Rao of Hyderabad who says he bought a builder floor in Hyderabad. The building has more than 6 units and the construction quality is not up to the mark. Can he approach RERA?
Yeah, he can.
According to Mr. Khandelwal's interpretation,
8 units should have been there for a project to be registered with the RERA and should be. But he says that nothing doing. Now, even it's a project where a buyer has bought from the developer, a contract has signed, so RERA is there to adjudicate that contract, and as per the RERA's agreement. Not as per, he says that if suppose somebody has signed or sold and purchased certain things according to their own agreement, he says that that will not be fulfilled. After 1st May 2017, all the sale purchase has to happen on the RERA's form.
Absolutely. And the RERA regulations hold.
Yeah.
Arun Katoch of Bangalore says, how can a buyer know that a particular issue falls under RERA or not?
Everything is under RERA.
All issues should be under RERA.
Now, if a project, suppose a developer is not registering with the RERA, does it mean that you cannot go to RERA? And only if a project is registered with the RERA, then only you can go to the RERA? No. You can ask and you can go to the RERA requesting him to direct the developer to register it with the RERA. And if that gentleman, that developer is not registering with the RERA, RERA will file a case against him, file an FIR against him in the police, and he can be arrested. The RERA can ask him to arrest.
Right. There is Sandeep Gupta of Faridabad who says his flat is not registered with the authority, but possession has been obtained. He noticed that the builder has not made any provision for fire safety inside the flat. Can RERA help in this matter?
Yes, he should go to the RERA.
Just go to RERA. You have to go to Haryana RERA because this is outside of
Panchkula.
This has to be.
They are also active, very active.
There is Monu Kumar of Gurgaon who says, is it possible to check online details of a project located in Gurgaon? Not yet. The Haryana RERA and Gurgaon RERA websites are still under preparation. Dhaneshwar Singh of Delhi says, what is the purpose of Delhi RERA? Will it also take care of issues for any upcoming DDA flats in case of any dispute, or is it only for private builders?
No, only for private builders.
For any builder, if a property is registered, if a property is under construction and there is a sale, then it should be under RERA. And this is something that we had spoken with Mr. Gautam Chatterjee, and one of the things that he mentioned was, if there is a sale, an agreement to sale between whether it's an authority, a builder, whichever authority, if you are buying and selling a property, it does fall under the purview of RERA.
And you have a redressal forum as a RERA.
You have a redressal forum in RERA. So, today's issue is all about sensitizing the public. It's an important issue. If you've got a project before RERA, are you helplessly watching while people whose projects are registered under RERA get the benefits of it, and are you left out? Basically, Prabhakar, it's the secondary market. It is a market where projects have been handed over and today the consumers are living with it. Can there be recourse? And Haryana RERA says, yes, there can be recourse.
There can be recourse, yeah.
Thank you so much for watching This Week in Property. I'm Jayashree Kurup. This is Prabhakar Sinha.
My pleasure. Thanks.